Yeah, please, Your Honor. I'm paying for listing of a ratable matter filed yesterday. Maybe listed on Monday next month.
May everyone. In item number 16, I'm appearing for Revenue Department. I'm seeking a further 6 week time to file affidavit.
Who's for the other side?
I am for the, I
Appellant.
am for the.
Any objection? It appeal, what affidavit?
On the last occasion, Lordship has directed us to file affidavit because we did not file affidavit in the single bench.
single bench.
That is good.
Okay. Mr.
A Bhattacharya.
A. Bhattacharya appearing for the revenue
Yes.
department that will be filing affidavit within
6 weeks.
Mr.
Sham Hussain.
Huh?
Sham Hussain.
Hussain appears for the appellant. This is the matter. After 6.
Obliged.
आपका application
Give a date.
obliged.
May it please your lordship, with the consent of the other side, I beg to mention item number 1 and 2. The arguing council have some personal difficulties today. I have circulated the notice yesterday.
Okay. Who's for the other side?
Learned, the department in council for APSC and finance, your lordship.
They paid their
Yes, yesterday only I have circulated.
right, the prayer for adjournment, which had been circulated by way of memo yesterday. This matter, when
After vacation, your lordship. Deeply obliged.
No. Item number 5 and 6, madam. With the
Yeah.
consent of the petitioner, madam, I have already circulated the mention there. As a slip, madam.
for the, who's for the petitioner?
I am the petitioner.
Okay, right. On the prayer for adjournment made by Mr. S. Bora, and counsel for the respondent, which has not been objected to by the petitioner's counsel. This is the matter after,
Vacation, madam. First week of November.
after the vacation.
No, he is asking for 7 November.
After the vacation,
Lordship, lordship.
May it please your lordship.
you all don't want to have it heard.
Well, his senior is out of station in the month of October. Entire month of October.
This month. Okay, this is the matter in the month of November.
Lordship.
May it please your lordship. I beg to mention item number 14, lordship. Lordship, this matter relates to Board of Revenue, lordship. Well, late for appropriate base, lordship.
Huh?
Appropriate base, lordship.
Board of Revenue,
Lordship.
where is the appropriate page? Board of Revenue.
Division based, lordship.
I think it can be heard by division bench 1 also. Huh? The foreigners matter or what?
No. Revenue, lordship.
Then?
Division based, lordship.
Why? Where does it say? Show me where division bench 2 is take up what matters? Board of Revenue. Page. Okay, right. It has been submitted at the bar that the matter relates, that the matter is a Board of Revenue matter, which is to be heard by division bench. Accordingly, leave this matter before the,
Next week, lordship. Next week.
in the next.
Obliged.
Please, your lordship, I beg to mention an IA criminal in a case for suspension of sentence and bail, lordship. It was filed in 16th of July, lordship, but it has not been listed. I'm paying next week, Monday. Much obliged.
May please, lordship. I beg to mention for item number 17, your lordship. In this case, Mr. Senior Counsel will argue the case, lordship. So he is not ready to take.
He's not ready today.
Yes, my lord. As per my.
Which senior counsel is not ready?
He is just your lordship. He is, I think, another case is there. So. So any date, after vacation, immediately after vacation. Only one date.
Right, on the prayer for adjournment.
I may assist.
Staff of Ms. Yes, I can then take off for the appeal. This is the matter after?
Vacation, any date may be fixed. Any date.
After, no need of.
Master, please.
May I please your lordships? I spoke with suspension of sentence. Paper book is there. Lordship.
Arey, we are ready.
No. Lordship, the POXO is there. Lordship.
I know, it's a, so accordingly, release this matter for hearing after the vacation. Yes,
Lordship, they are only pressing internal IF, Lordship. In this case, the paper book also ready. Lordship, kindly have a look at the 164 statement of the victim and the deposition for the learned. Lordship, kindly come to page 75 of the paper book.
yes,
Lordship, what? 75. It is the 164 statement of the LS victim.
yes,
Lordship, may I read?
yes, yes.
The particulars mentioned above are to my knowledge. On 4/11/2021 at about 6 p.m., accused such and such asked me to visit his house. When I went to see his house,
Give me.
this case, Lordship,
Just a minute. Okay, you have not received the paper book, I think. Yes,
Lordship, in this case, what happened? Learned trial court relied on the evidence of PW 2 and 10.
2 and 10.
2 and 10, who claimed to be the eyewitness. But in the Azahar, Lordship, kindly have a look at the Azahar at the very beginning of the paper book.
Give it to him. You have got,
No, Lordship.
no, you have already got.
Then Lordship.
As per this office note, has been furnished upon Miss N. Das, learned additional PP
I'll get the instruction.
on 19/9/2024. 19/9. Last year.
Last.
Yes,
Lordship, Azahara was lost by wife of the LSP. And in the Azahar, there was no mention the name of the eyewitnesses. That is very important.
no? Where is the requirement that it should be
Lordship,
mentioned?
it is important. Basic fact of the
Show me the law.
prosecution must. Lordship, I am relying on a judgment of the Honorable Apex Court. Lordship, kindly.
Eyewitnesses have to be mentioned in the thing. Where?
Lordship, para 9 and 10. Lordship, I have only single, I could not.
So you are without,
Without copy, Lordship, but para 9 and 10, Lordship. Yes.
there's nothing here. See. There's nothing. That's all. Anything else?
Lordship, and in this case, another thing, PW 12 denied. Nobody was present at the time of occurrence, Lordship. And he was also not declared hostile by the prosecution side.
Your number 2 point is what? What is your number 2 point just now? What did you say?
Lordship.
12.
Lordship.
What? PW 12?
Who denied? Nobody was present at the time of occurrence. Only he was alone. But he also
PW 12 said that.
12, Lordship. But he
That,
also did not,
that nobody was present
Lordship. They are at the time of incident.
at the time of incident,
Lordship.
at the place of occurrence.
Lordship. Lordship.
However, there was another eyewitness.
But according to the prosecution, two eyewitness PW 2 and 10.
2 and 10. And,
But
and
12 denied.
12, is he eyewitness?
But he rushed to the place of occurrence immediately after.
So after the incident,
Ah.
at the time of the incident, he was not there.
He was
Then-
also not there. But he also, when he reached there, nobody was there.
Maybe, but prior to him reaching there, they must have left.
That's how, Lordship. Lordship.
Nobody was there because Lordship, the victim Islamuddin was already shifted to the hospital in injured condition.
And Lordship, another thing, Lordship, injured witness was not examined.
See that page?
Page number, I have some different pages because it is my
The
paper.
evidence of PW?
PW 12, Lordship.
Okay. W12, let me see what it is.
That is right. This thing also, also says that same things.
Lordship.
Already shifted.
Lordship.
Already
Shifted. Shifted.
And other aspect, Lordship, there are two victims. One injured witness who expired during the course of time. He was also, his statement was not recorded by the prosecution. Why?
His statement was not recorded.
He is one of the injured witness. There are two.
His statement was not recorded in the hospital.
Even after the occurrence, also even after the discharge from the hospital, also his statement was not recorded.
So,
But during in course of trial, he expired.
Hmm.
He is the only eyewitness. At best,
according to you.
yes, he was there, but his statement was not recorded.
So two injured persons.
Lordship.
One died, one
At
survived.
this spot, and one after about during in course of trial, the other one.
At the spot.
Lordship.
And one died during the trial.
Lordship.
Lordship.
But his statement was not recorded. Why?
PW 16, Lordship. Srimati so and so, judicial magistrate recorded a confessional statement of the victim, Lordship.
But that confessional statement rejected by the learned trial court.
Confession statement of victim.
Victim, sorry,
Accused.
accused, Lordship. I'm sorry. Accused. That is PW 16. And the deceased were father and uncle of the victim, accused, Lordship. The son is PW2.
Father and uncle.
Uncle Lordship.
Father and uncle, land is
So the accused is the son.
Son
son
of the
Lordship.
injured witness.
Same.
And there is a land dispute according to the finding from it is from the
Dispute with the father.
Lordship. But that was not stated by any of the witnesses.
So
Any of the witnesses that was not stated before the learned.
according to you, I'm not talking about. According to you, there was a land dispute or not?
I have no such instruction, but learned trial court came to a conclusion that there is a land dispute. That's why I am saying. Learned trial court.
Madam, what is that word that we use when, the confessional statement? We take back the confession, retract. Retract your confessional statement. Where?
Rejected and the learned court will also rejected.
Where is the?
Lordship.
Page number?
This is a
Lordship,
retraction.
it is in the judgment, Lordship.
He was given reflection of 5 hours also, then he made the.
No, I'm not on that. Where is the retraction? I want to know when he did.
Lordship.
Probably under, when? Let us see his confession. Was it exhibited?
No, Lordship.
Not exhibited. Oh, if it is not exhibited, then no, it's exhibited. Page 44.
But I think not it is exhibited, Lordship.
Nine.
I don't know. Please come to page 44 and look.
Lordship.
Please look at page 44. Just before cross examination. Exhibit 10 is the set confessional statement of the accused. Page 170. Okay. Page 170 is clear. You have not only
But that was discarded by the learned trial court.
that-
Confession part, Lordship. There is a clear finding of the learned.
yes, where is it?
Page Lordship 129. Para 71. The recording of confessional statement cannot be a mechanical one, but it is a sacred duty cast upon the officer who records the confessional statement of an accused. From the evidence of the PW 16, it appears that the confessional statement of the accused was recorded on 27/7/2015, and on that day itself, the accused was arrested and produced before the learned CGM, who endorsed the record.
Okay, no, this confession statement it has held that cannot be set to be voluntary. Okay.
Lordship.
Let us see the evidence. Let us see the evidence of PW2. Who is PW2?
He is the son of the Lordship 15.
Son
Who
of the
ex-
victim.
Lordship.
Your brother.
Lord cousin brother.
Acha, son.
Uncle and father. Uncle expired,
So this PW2 is the son of the uncle.
uncle. Who expired?
And 10? PW10?
He is a shop owner, a pharmacy owner, Lordship.
He's got any enmity with you? You have got any enmity with him? With PW10? Any enmity?
I think
No. Have you got any enmity with PW2?
no.
No.
But that may be. But once they are Lordship denied by PW12, that nobody was present, was not declared.
Mr. Council, it is like this.
Lordship,
There is a fight outside this corridor.
Lordship.
By the time and there are two persons injured. By the time I go out, the injured are gone to hospital. It's like that only. Here also, his evidence, PW12 himself says,
And nobody remained in the.
everyone had gone. Everyone had gone off. Even that had been taken to hospital. So what will you want to see?
And Lordship, other aspect, Lordship, in the Ezahar, name of the eyewitness was not stated. Basic-
Yeah, this judgment doesn't help you.
Lordship,
Where does it say that the FIR has to be a cyclopedia of everything?
not that, but basic fact of the prosecution case is to be stated in the Ezahar.
Yes, they did. Yes.
Not Lordship, eyewitness was name of the.
They-
It is, Lordship, I am relying on
Okay,
para 9 and 12.
Okay, we have heard.
Lordship, my sub, this is.
We have heard.
Lordship will, I'll leave it to you.
Yes, it's better. I think no point.
Yes, Lordship.
We can dispose of the entire appeal also.
No, Lordship.
Huh? Why? We've heard everything. Nothing remains.
Detailed hearing is necessary.
No, not detail. What is there? What detail? The evidence is there already.
No, Lordship.
But no what? No what?
I have to rely some more judgment regarding the Lordship, whether name of the eyewitnesses is required to given in the Ezahar. Yes, sir.
Even the name of the accused are not required to be there in the FIR.
No, that is true. But if it is the case of the
It is not required to be there.
Lordship,
Question of name of witness. Supposing three of us, say around those three at the back, they were with me, and I had seen an incident. Supposing I submitted an FIR and I don't know their names, then what will happen?
then something different, Lordship. Then something different.
It
But
doesn't mean that
if-
everyone has to know.
But here it is a case that everything is known to each other, Lordship. Yeah, that's why I'm after vacation any date, Lordship, appeal may be fixed any date. And Lordship, IA may be disposed.
Okay, right. And Ms. L.R. Mazumdar, learned counsel for the applicants. Applicant also heard Ms. A. Begum, learned AP. The applicant has prayed for suspension of the sentence imposed upon the appellant. Applicant, in pursuant to the judgment dated 4/1/24, passed by the Sessions Judge Hailakandi in Sessions Case number 2 of 2017, by which the appellant has been convicted under section 302 IP. The facts of the case is that the appellant had been convicted on the ground of killing his father and uncle with a dove. With a dove. And the Learned Trial Court had based its conviction on the basis of two eyewitnesses, that is PW2 and PW10. PW2 is the son of the uncle of the appellant, while PW10 is an independent witness. Having an independent witness, having no relation to the applicant. Next para. The counsel for the applicant submit that as the names of the eyewitnesses were not mentioned in the FIR, the trial was vitiated. He also submits that the evidence of PW12 would show that nobody was present at the place of occurrence. No, full stop. As such, PW2 and PW10 could not have been at the place of occurrence at the time of incident. At the time the incident occurred. when PW12 had had given his testimony that no one was present when he went to the place of occurrence. He also submits that the father who died instantly at the place of occurrence,
Uncle,
he submits that though the uncle had apparently had died at the place of occurrence, the father of the appellant died during the trial proceedings.
Lordship.
However, his testimony was not recorded.
Even his statement was
Statement was not recorded by the police,
lodged police and also before the magistrate.
by the police or the magistrate.
No.
Correct? Is that correct? He says that the statement of the father was not recorded by the police.
Or under 160.
Next. The learned APP on the other hand submits that the testimony of PW12 would go to show that by the PW12 had gone to the place of occurrence, gone to the place of occurrence, the deceased and the injured father had already been shifted to hospital. Now, no. It came to the place of occurrence. Uh, the injured father had already been shifted to the hospital in an injured condition. He had already shifted to hospital. Huh? Also, PW12 had not witnessed the incident as he had arrived at the place of occurrence after the incident had occurred. Next. The additional PP submits that when there are eyewitnesses to the crime, especially independent eyewitness, there was no reason to disbelieve the testimony of the eyewitness. We have heard the learned counsel for the court. The evidence of PW12 clearly goes to show that PW12 had appeared as the place of occurrence only after the incident had occurred. And he was not a witness to the injury caused to the father of the applicant or the uncle. The evidence of PW2 and 10 clearly shows that they were eyewitnesses to the applicant being the perpetrator of the assault on the father and uncle, on his father and uncle with a doubt. Considering the above, we do not find any ground to allow the application. The same is accordingly rejected. Then in the main case, you write, list the matter for hearing when?
After
No, why after 24th?
no,
24/9.
no,
Sugar ready.
I require some time
Why?
for
What?
prepare.
Say nothing.
Lordship, but I have to done.
After vacation.
After
Puja vacation.
After ready. List the matter after. Ready.
Lordship, can I?
You're right. In the main case, you're right. Also, a copy of the paper book has been provided to Mr. L.R. Mazumdar in the court today.
Obliged.
You have to get it from Ms. Das.
I have.
May it please your lordship. Lordship, may kindly see last order, my lord. There is a direction to take some instruction with regard to the compensation of other state in India, my lord. So I have some state, my lord. Sure. Yes, sir. About 14 state, my lord.
Huh?
14 number of state, my lord, in India.
Have you given a copy to your friend?
Yes, yes, I am. It's only deliberating.
Yes.
In that case, I have to take instruction because his original case was, my lord, making a claim of 50 lakhs as compensation as well as challenge to the validity of the regulations, my lord. So now, because last occasion, my lord, Honorable Chief Justice wanted that to get a comparison, my lord. Now, if we see, my lord, most of the states around 5 lakhs, Assam is 4 lakhs.
Yes, then Mizoram so poor, they are making it 10 lakhs.
Maybe, my lord, their claim is lesser, my lord, because in Assam, my lord, we have seen, in fact, one of my data indicates, my lord, from 18 to 2023, 5 years, we paid, my lord, 4.17 crores as compensation, my lord. And this is a scheme, my lord, not mandated under the Electricity Act. It is on our own volition. APDCL regulation was framed, my lord.
So you look into this.
I can definitely talk to the authorities, my lord, if it can be enhanced.
Right. The petitioner's counsel. Has submitted a chart showing the compensation amount by various states in respect of fatalities resulting from technical accidents, which are as follows. Take it back. Wait a minute. Mr. Goswami, the learned, P. Goswami, the learned edition. AG. Submit, they would like to obtain instruction.
My lord, may kindly indicate, my lord, as to whether, my lord, APDCL is in a position to enhance it, financially.
APDCL. And as to whether they are in a position to enhance the rate of compensation being presently provided by them for electrical
Excellent.
accident. Accordingly, this matter on
2 weeks. Maybe it has to be placed before a board, I suppose. If we did take a call on that.
okay, when,
Let it after vacation, you know.
okay, list the matter when on 13th, 14th,
14th of October.
14th.
Mother, I'm appealing for Asrama 3. My name is
Mr.
S3. That's all.
That's a paper is point number 3.
All right. Just a minute. My lord. Question for question. See, since the regulation was framed by the AERC, my lord, I will take instruction from APDCL as well as government of Assam.
CL and
The government of Assam.
and the government of Assam. Huh?
Okay.
This DNA method that your lordship earlier on the last week called the FSL expert and had her. on the phone.
Ah. That's not matching.
Not matching. That.
You have filed an application also.
I also have yes.
What I, what?
I lordship for suspension of sentence and releasing on bail, lordship. Because his first application was rejected only on the ground that DNA for conducting DNA, his custody may be required, only on that count. And victim statement already your lordship has seen that she said she do not identify the perpetrator. So considering both aspects, lordship, we released on bail. That is not.
Lordship, paper book is not yet ready, Lordship.
Huh?
Paper book is not yet ready, Lordship.
That's all right. But with regard to the bail,
Yes, Lordship, that regard also, Lordship, since conviction is more than 10 years, Lordship, we have to file our objection. And paper book is not yet ready. Lordship.
you can file it on the you don't have to have a paper book for filing it now.
And, in
This is
fact,
a
Lordship, I'm
criminal-
handicapped today, Lordship.
Huh?
Appeal is not before us, Lordship, the paper copy of the petition. Lordship. I'm nearly
It will
engaged.
be-
today.
That will be in your house, that will be in your office,
No.
the appeal.
So we'll file our objection or let the matter be heard at length in some other day, Lordship. Because
Lordship has already heard this matter earlier also. And that for DNA also it took around 2 years, lordship, since 2023 is in the.
You file it by, we'll list it next week. You file it within 1 week. If you do not file it within 1 week, we'll dispose of the application even in the absence of your. Okay.
Lordship,
You see, the thing is this,
yes,
this victim
Lordship,
who is not a young woman,
yes, Lordship.
she is 48 years old at that time. And she has said that she did not recognize, she did not see the face of the person who raped her.
Lordship.
Then what remains?
May it please the court, my lords. Plus, the subject matter of this writ appeal is whether the disconnection of the electricity connection from the premises of the writ appellant is in fact legal or not, my lords. Now, the facts of the case in brief is such that, my lords, I'll straight away take your lordships to the relevant annexures because the annexures will demonstrate the entire chain of events that transpired. Your lordship, may kindly come to page number 45.
No. So your electric connection was disconnected.
Yes, my lords.
So you have been asked to make a new connection or what?
My lords,
You agreed with, basically.
But our contention is that the entire disconnection is illegal in nature. Therefore, we are entitled to the compensation as well as the reconnection by them, Millets. Because the disconnection itself is not tenable in the eyes of law, Millets.
Compensation for
Loss of business, Millets, because this property, we have annexed documents in our pleadings whereby this property was rented out.
how do we know how much you have, how much loss you have made?
The agreement, the tenancy agreement was annexed and is part of the record.
How do we know how much money loss you have made?
Millets,
How do we quantify your loss?
If at all a finding is given by this honorable court,
Need to go into evidence.
Millets,
How do you quantify your loss? What are you doing? What are you doing? What is the petitioner doing? What work does he do?
well, he's a designated senior advocate.
He's a designated senior.
Yes,
How is he going to quantify his loss?
Millets, I bow down to your lordship's submission, Millets.
If you're going to ask for compensation,
Millets.
then you'll have to prove your loss.
Right,
And
Millets.
how do you prove your loss? By evidence?
Millets.
Huh? If
Millets.
you're going to take evidence, then this is not the court.
Right, Millets.
Then,
Millets, as far as the quantum of the compensation.
so you are
is
not
concerned-
going into the issue of compensation, or are you going into that? Are you going to press?
If your lordship, so Millets.
We're leaving it up to you. We have a solution for both.
Right, Millets.
So depending upon the route you take, we will pass necessary orders.
Millets, as far as the quantum is concerned, Millets,
Yes.
liberty may be granted to us to approach the concerned court, Millets.
There's no question of liberty being granted. The liberty is always there.
Right, Millets. Then, Millets, insofar as this writ appeal is concerned, Millets, we are only praying for the observation and finding that the disconnection itself is illegal in nature, Millets.
Observation.
Finding in the
Yeah.
finding, Millets, because the learned single judge,
Why now? So has the electricity been restored to you?
not yet, Millets.
Not yet.
Not yet.
And you're working by candlelight.
Millards, that property was rented out, that it did not house the office of the petitioner, Millards. That was rented out.
Does not house the, so it has been rented out to who?
To a third party, Millards. It was rented out, yes,
See,
yes, Millards.
that third party is not aggrieved.
Millards.
The third party is not aggrieved.
Millards, at that point in time,
No, now,
Right.
as on date. Huh?
right, Millards.
Yeah?
They're not there, Millard, because there's no electricity connection. So there's no
There-
tenant as of now. We are the owners, Millard.
There's no electricity connection in your building.
Yes. In my apartment, in my flat.
Well, yes.
Yes, Millard.
Now, why is there no electricity connection?
Because it was disconnected by the.
And have they offered to give you a connection?
Well, what they're saying
Yeah.
is that we will have to apply for a fresh connection, Millard,
Okay,
which
and-
will also incur fresh charges and everything, Millard, with the installation of a new meter and also all the incidental charges that will come along with the fresh connection, Millard. Our contention is that, Millard, since the disconnection itself was illegal, then the question of fresh connection does not even arise because they would be obligated to restore our original.
What is the difference in cost between the reconnection and the new connection?
Millard, that would
If
be,
it's only a question of money,
Millard.
that can be taken care of.
Also, Millard, the entire hassle of
Or is it
applying and Millard.
or is it a ego problem now?
It most certainly is not, Millard. It's what
Looks like this. Yes.
well, at this juncture, Millard, it also pertains to the administrative hassle that will come, the logistical hassle that will come along with the fresh connection, Millard. But just for the purpose of this ritual, Millard, we're only pressing that a finding may be given because the learned single judge has already given a finding that the termination, that the disconnection is valid in nature. So we're aggrieved by that aspect. Now, insofar as the quantum is concerned,
Let us see if the termination is valid. Yeah, so
Right.
are you challenging the termination?
yes, Millard.
Challenging the,
Yes, Millard. Now,
let us see.
yes, Millard. Now, there are a slew of grounds that we had taken before the learned single judge that we are taking before this honorable court also. Now, the first ground that we're taking is that, Millard, according to the Electricity Act and the state's own regulation, the respondents, the APDCL, is mandated to provide us with a notice giving 15 clear days for clearing our dues, Millard. That was not done. That was not done in this case. No notice as such was served to us. Number two, their contention in respect of our claim that no
Clearing arrears.
arrears, Millard, dues, Millard, because this was peak COVID period, Millard, and it was.
So has the law changed between pre-COVID and post-COVID?
But
Let us be clear
Right.
for the law. You see, if the law hasn't changed,
right,
situations, facts might change, but the law hasn't changed.
no, Millard, it has.
So the law is, according to you,
Yes, 15 days.
to post-COVID,
Right.
there has to be 15 days notice for clearing your arrears.
Yeah, right, Millard.
So you had arrears
Millard.
and they did not give you 15 days notice.
Yes, Millard. Now, if I would take your lordship's
Then, if you do not clear your arrears, what is the penalty?
they give us a notice saying that if you do not clear your arrears within 15 days of the receipt of this notice, then we will disconnect your connection. That is
Show me the provision.
Yes, Millard. Your lordship may kindly come to our written submission where we have already extracted all the relevant provisions from the relevant statutes, Millard. The written submission is part of the record. Your lordships have it.
This content, is this the one?
Millard, that does not appear to be ours. Written submission on behalf of the petitioner, Millard, the writ appellant.
Oh, written argument,
Written argument.
case law and rules.
Yes, yes. With case laws and rules submitted by the appellant. Now, if your lordships would kindly come to page number 24. Page number 24. The preceding page is the front page of the Gazette notification. The relevant portion is at page number 24, chapter number 8, under the heading Disconnection and Reconnection. Your lordships have it?
Temporary disconnection.
Yes, Millard. So the first step is temporary disconnection. Now, what does it say? 8.2.1, Millard. Where a person neglects to pay any charge for electricity or any other sum due from him to a licensee by the due date mentioned in the bill in respect of supply, transmission, or distribution or wheeling of electricity to him, the licensee may, after giving not less than 15 clear days, very important words, I'd like to lay emphasis, not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off supply of electricity until such charge or other sum together with any expenses incurred by him in cutting off and reconnecting the supply. So the provision there, regulation is clear that the 15 clear days has to be given to us. Now to that, what they say, what they submitted before the learned single judge is that, my lord, this notice, according to them, is already contained in the bill. This is the contention that they've taken. Therefore, my lords, at this point, I'd like to take your lordships to the bill itself. Your lordship may kindly come to the writ appeal, my lords, at page number 45, annexure A1.
Page 45,
Yes, my lords. Now, before this, what
the writ petition,
writ appeal, my lords?
writ appeal. Yes,
Now, my lords, your lordship will notice before I proceed to the aspect regarding the 15 days clear notice, this bill is dated 14th of March 2022. Your lordship may kindly note, my lords, 14 March 2022, and the due date given is 29th of March 2022. 29th March. Therefore, under no circumstance can they disconnect the electricity connection before the due date. It naturally flows, my lord. Now-
so this will be the notice, can it be the notice? No.
That's what we are saying, no, my lords. And under no circumstance.
According to them, this is the notice.
My lord, this is a PDC bill. It's a PDC bill. It's a PDC bill, my lord.
What do you mean PDC bill?
Permanent disconnection bill, my lord.
When is that? Where do you
That
get
is, my
the
lord,
PDC?
billing details at bottom, my lord. This is a PDC bill.
Yes, my lord. Now,
Just a minute, where?
Page 45 at bottom, my lord. This is a PDC bill. After the permanent disconnection has already happened.
No, where does it say PDC bill?
My lord, billing details. This is a PDC bill.
yes.
Okay,
So here the notice period won't be there.
But I'd like to clarify the position. If your lordship may kindly come to the counter affidavit.
now what do you mean by PDC?
Permanent disconnection, my lord.
Permanent?
Disconnection. Because the area still got some area still gets accumulated, and because they have not cleared the bill, that is why the areas.
This is not the original bill.
No, my lord. Yeah, this is kind of a final bill, and it will go on recurring. Well, my lord, the original bill is at page 77. My lord, may get it, my lord.
Yes.
My lord, there is a disconnection notice along with the bill, and under section 56(1) of the Indian Electricity Act 2003, power supply to your premises will be deducted at any time.
Disconnected.
Yes,
Disconnected.
will be disconnected at any time due to non-payment of area amount ignored if already paid. So this is a format of bill format
At any time, my lords.
at any time.
At any time.
Yes.
When the regulation itself stipulates
Under-
15 clear days, my
Just
lords.
just let me just clear to the question. Under section 56(1), my lord. And my lord, obviously there's a due date here, that is 16/6/2020. And this was given to him on every month. So my lord, a person who is sitting in Manipur or anywhere, he knows that he has a house running in Guwahati. He knows that he has to pay the electricity bill. And now is not the stage that you have to go and give the bill offline. You can give it online. So my lord,
So there is a 50 period given to you.
My lord, that is not the bill. I'll take your lordship to the relevant bill at page number 79. 79. Now, this is the bill which directly precedes the disconnection. This bill is dated 13th of August 2020, your lordships.
Correct.
13th of August. Now, your lordship may kindly come to their own document at page number 85.
No, this bill date
Yes, my lord.
13/8/2020,
Yes.
due date 28/8, again 15 days.
Yes, yes. Your lordship may kindly see when it was disconnected. Your lordship may kindly come to page number 85. 85 of the writ appeal, my lord. 85. The format 18 intimation. Your lordship has it?
Yeah.
Yes, your lordship may kindly come to the body. This is to inform you that your supply has been temporarily disconnected with effect from 28/20, my lords. 28. Now the date is 13. If 15 days are to be calculated, the last date comes to 28, as rightly pointed out by your lordship. And by their own admission, they have disconnected it on 20, merely 7 days after the first date, my lord. So this is,
Several bills, not only
my
one
lords,
bill.
we have raised the question. Malab, we have raised the question of them not serving the bills to us, to which they have not given any responsibility. We have raised specific averments in our petition that the bills were never served to us, Malab, and they have not been able to exhibit at any stage, at any point in time, that the bills were in fact served to us. Because the regulation also stipulates a procedure under which or by which the notice is to be served to us. So this is my first ground, minutes. That 15 place.
So how bill has to be served
Minutes.
on you?
Yes, minutes. I'll take your lordship to 10.3 minutes.
Just a minute, just a minute. Prior to that, in this page 79, where is the arrears?
My lord, at fifth column, my lord, from the bottom. Total bill amount, miscellaneous area, current charges, area principal.
So he has been having arrears.
Yes, my lord. The area was already in, and my lord, the one which is showing that was issued on 16/11/2021, and this was an intimation to the consumer after temporary disconnection of
Page, which
supply.
page?
Page 85.
The notice that I pointed out to. I'll
My
come to
lord,
that
see
also,
the-
my lord,
my lord, see
because
the
that
headline.
intimation, format 18 intimation, according to their own regulation, is mandated to be served upon the licensee within 24 hours, and by their own admission was served after a year, my lords.
You have not been paying your rent. Your
Well, this was peak COVID period again, as I said at the starting of my submissions, Mullahs. And I'll straight away take your lordships to the nature.
Whether it is pre-COVID or post-COVID, everyone was paying it online.
Mullahs, there is a procedure for service of notice under the regulation, and we have made specific averments in the petition that the bills were not served to us at any point in time, Mullahs, to which they have not given a counter. To which they have not given a counter, Mullahs. The regulation 10.3 of the regulation stipulates the method or the procedure by which the notice is to be served upon us.
Acha, there is one thing. You have given a notice, this bill,
My lord.
at page
86, my lord.
no, 85 is there. But what about that other one? It's page 79.
79.
Yes, my lord.
79,
My lord.
you have given due date of 28/8/20.
Yes, my lord.
Then why didn't you wait till 28/8?
My lord, as because, my lord, we have stated with effect from. There was already an area on place. Because the earlier two bills also, I would say, they have not paid. So as per the temporary notice period, the 15 days was already over.
No, but then the facts is
Yes, my lord.
that in this page 79,
Yes, my lord.
you have also added the area.
Yes.
Yes, my lord. My lord may see this. This is to inform you that your supply has been temporarily disconnected with effect from 28/2020.
Correct.
Yes. So, my lord, thereafter, my lord, see, due to non-payment.
Correct.
Now, so that means with effect from 20th August.
Correct.
Now, my lord may see the bills of 70, page number 78 and 77 ones.
No, that is all right.
Yes.
See, the issue is this.
Yes.
You have kept on adding the areas.
Yes, my lord.
to the bill amount.
Yes.
Okay, the
Yes, my
area.
lord.
Now the page 79
Yes, my lord.
is the bill,
Yes, my lord.
total bill including the area.
Yes, my lord.
And you have also allowed the petitioner
My lord.
time till 28 August
Yes.
to also pay the area.
Yes, absolutely, my lord. My lord.
Given time till 28 August to pay the arrears also.
My lord.
Why suddenly have you acted 8 days prior to 28?
My lord, we have temporarily disconnected it. Yeah, I'm coming to it. I'm coming to it in this way, my lord. Because, my lord, the provision says, as per the temporary disconnection, it says that when, my lord, I'll just take the provision that is in, he has annexed it, my lord. My lord, page 24.
Yes.
My lord, where a person neglects to pay
Yes.
disconnection due to non-payment of bill amount.
By the due date mentioned in
Yes.
the bill.
Yes, my lord, no. Where a person, if I may, my lord, pay in respect transmission of wheeling of electricity, the licensee may, after giving no.
Please.
Yes, my lord.
Please don't jump.
Yes, my lord.
Please read slowly.
Yes, my lord.
From where a person neglects to pay.
Yeah, where a person neglects to pay any charge for electricity or any other sum due from him to a licensee by the due date mentioned in the bill.
Full
Yes,
stop.
yes, ma'am.
By the due date mentioned in the bill.
Yes,
In the bill,
yes, my lord.
page 79.
Yes. Now, what am I
Wait
saying?
a minute. Finish.
Yes, yes, my lord.
As per page 79,
Yes, my lord.
the due date mentioned in that bill,
Yes, my lord.
28th August.
Yes,
Correct?
yes, my lord.
You have acted prior to 28th August. You have acted on 20 August.
Yes, now may I just submit here, my lord? My lord, these bills, we had acted on 20th August as because they were earlier two bills which he has not paid.
Yeah, okay.
That is that, my lord, 77 and 78.
Correct. Correct.
And my lord may,
Yes.
yes,
That 77 and 78 bills
yes,
have now been made arrears.
yes,
They have been included in the page 79 bill.
absolutely, my lord.
Arrears also have been included.
Yes,
Yeah.
it's included. Now, my lord may see.
It's like this. It's like this.
Yes, my lord.
Supposing I take a loan from him,
Yes, my lord.
brother,
Yes, my lord.
1 rupee,
Yes.
or say 10 rupees,
My lord.
and I've got to pay him 1 rupee per year.
My lord.
Okay. And I don't pay him for 2 years. So it'll be by the end of 2 years, I'll have to pay him 12 rupees.
Absolutely, my lord.
Then he says that, look, if you don't pay me by the 3rd year, I am going to take away your house.
My lord.
Supposing he says that. But in the 3rd year, he doesn't take away my house, but he gives me another notice saying that, look, now you owe me 13 rupees. And unless you pay me by April, I'm going to take away your house. But before April comes, he takes it away in February. If that is the case, what are you doing here?
My lord, I may just supplement it in a different way, my lord. What we have done here is this. We have accumulated and we have seen for the last 2 months, this person has not paid the bill.
Correct.
So as per the temporary connection, the 45 days period was already over by then.
What 45 days are you talking?
Yes, my lord. My lord may see at the bottom.
Yeah. Which page?
Page 85, my lord.
Yeah.
Now, if the cause of disconnection is not removed to the satisfaction of this office and above amount is not paid within 40.
That is the issue subsequent to the issue.
Yes.
It is the first issue. Yes.
Yes, my lord.
Is with regard to, you have given him a date.
Yes, my lord.
Please do it by 10th.
Yes.
But prior to 10th,
Yes, my lord.
you have acted on 5th. That is his case.
Yes.
My lord, may I just submit here? But he did this. This was issued on 16/11/2021,
Maybe.
and he was not paid by then, my lord. By then also he has not paid.
16/11/21.
This was issued on 16.
No, but then look at the contents of what you have said. You have said that has been collectively disconnected with the effect from 28, 20.
Yes. So if you'd have yes, my lord.
Why didn't you could have said with effect 28/8/20.
Yeah.
Of course, he also, yeah, correct in a way, but then he has also got an ego problem.
Yes, my lord may see
The
the,
ego problem. You have not paid
But
2021 also.
what happened was the first annexure in the writ petition itself, the bill, the moment we were made aware of the arrears, we paid all the arrears, my lords. The receipt is also annexed in the writ petition, my lord.
They will take it up at 2.
Very well.
my lord, my lord was asking me with the question that why did you did it 28 and how did the amount come to 13,706 at page 85.
Ah,
So my lord,
page 85.
yes, 13,706.
I'm not on the amount,
Yes, and my lord is saying that why did you do
the dates.
date? So my lord, I just like to show my lord the bill 80 or page 80.
Yes.
My lord may see here, even though in page 79, the total bill amount was 4522.
Ha.
But at page 80,
Ah.
on the next month from 1/8 to 1/9/2020 and due date 17/9/2020, we have not calculated the previous area.
You have not calculated.
Yes.
Ah.
So my lord may also see that the billing cycle was also changed.
That's a different issue.
Yes. So my lord, and this was a temporary disconnection.
Which one? This page
16/11/2021.
One
was a temporary- Temporary disconnection. So if he would have paid the amount thereafter, we could have made it a connection. So this would not entitle him that we have done some kind of a fraud or we have unjust enrichment. Rather, my lord, despite this being intimated to him, and there was a permanent
Did he pay this amount?
which amount? My lord, he paid this amount.
But may I clarify?
This page 79. When did he pay this page 79?
Clarify on that point, my lords.
At page 304, my lord.
Yeah. 304?
No, I think page number is different, my lord.
No, the entire petition
Yes,
is up to
page 46. Page 46.
Yeah.
My lord, this bill was paid by him on 29th March 2022.
All the bills.
All the bills
Yes.
after the permanent disconnection was issued to him. After nearly 2 years. And that is that's the amount received was
Okay.
80.
Anyway, this
Yes.
page 85 is a temporary disconnect.
Yes. And the
Where is the final disconnect?
final disconnection is at page 45.
March.
14 March. Yes, my lord. 14 March was the due date and he paid within the due date.
No, my lords. 14 March. Due date is 29 March.
29 March is the due date.
And we paid on 29 March.
And they paid on 29 March.
Yes.
But this was already the permanent disconnection had already happened by then.
How, my lord? The meter status shows running.
Yes, the meter status shows running that.
Shows running. Last date is 29. I paid on 29.
No,
Yes.
page 45
Yes.
is the bill.
Yes.
Yeah, PDC, permanent disconnection.
Disconnection bill.
Yes.
Meter status has gone. Meter status shows the health of the meter. Yes, my lord, it's as per the ARC code.
Meter status shows running. Due date shows 29. I paid the entire arrears on 29 itself on the last date, and they say that permanent disconnection has already taken place before the due date. Even on permanent disconnection, my lord. Temporary disconnection, though, it's already there. But permanent also they did it before the last due date, my lord.
No, my lord.
These are all apparent from the face of records.
No, my lord.
Did you disconnect this?
My lord, this was disconnected from 45 days. 45 days after the intimation to him.
Oh, just a minute.
Yes, my lord.
As for page, when did you disconnect the electricity?
It was disconnected on 14 March 2022.
Oh,
My lord, it was if the cause. Sorry, my lord. Page 85. Sorry, my page 85 once. My lord will come to 85.
Page 85 is a temporary
Yes.
disconnection.
If the cause of disconnection is not removed to the satisfaction of this office and above amount is not paid within 45 days of this notice, your supply shall be disconnected permanently without any further notice. And my lord, we had already permanently disconnected the time. That is why it's a PDC bill, permanent disconnection bill. So it is not that on 14th March, we are going to permanently disconnect it. The permanent disconnection was already running. The time period was already running by then. And my lord, that is what even my lord will go to the written arguments once, my lord. Of his, where he has.
Just a minute.
Yes, my lord.
Two is, even if he paid the bill
Yes, my lord.
per page 45,
Yes.
it would still have been disconnected.
Yes, it would have not been disconnected.
Huh?
It would, the permanently disconnected would have, he would have only paid the ADR amount. He would have only paid the ADR amount because there was no running bill. My lord may see the PDC bill once at page 45.
You see,
Yes,
the bill period is for 1st February 22.
yes, to 14 March 2022.
20,
Yes, my lord. Now, my lord may see at the energy charges.
where?
Yes, see, my lord, at the right hand corner.
Huh?
My lord may see here total energy charge 0. Estimated charge 0. Deemed fixed charge, that is a fixed charge that we charge 0. Sorry, 1076. Electricity duty which we have to give, that we have taken. But adjustment amount so and so. It's only the ADR principal that we have taken. It is not a running bill, my lord. So it is nowhere he is trying to project a case that on 14 March,
Is this demand fixed charge?
my lord, demand and fixed charge is what we pay, is a fixed charge which we take it from the meter, and it's from the Electricity Duty Act, which we pay to the government for the revenue, my lord.
When the meter is running, my lord. Energy charge is 0 because there's no consumption. That's why. But all the other charges which are applicable when the meter is running have been taken from me. And the previous arrears are also exhibited in this PDC bill, my lords. That bill itself says last date is 29. On 29 I pay. And your lordship may kindly come to page number 46. Your lordship will see that the receipt it mentions is for reconnection. Reconnection.
What which one?
Reconnection, my lords. Your lordship may kindly come to annexure 8, page 47. 600, lords, is for reconnection, which comes after temporary disconnection. So on 29th, what we did, they told us that it has been temporarily disconnected. We said, okay, we'll pay all the arrear amounts on 29 on the last date. And then they said, okay, give us the reconnection amount and we'll reconnect it. And then they took the charges also for reconnection on the last date, Millards. And now they say that it was already disconnected before the last date by their own admission, Millards.
My lord, let him submit, then I'll come.
Yes, Millards. I'd like to exhibit certain more points, Millards.
Just a minute. Well, one of the first things that has to be decided, I think, is, you see, temporary disconnection in terms of clause 8.2.1
My lord.
required that disconnection could only be made after serving 15 days period.
Yes, my lord.
Now that 15 days service period, 15 days period has not expired in terms of your page 85, because the time limit was till 28 August, and you have disconnected it with effect from
Very fair.
August.
Yes. My lord,
Maybe done in 2021, but that has been that time period has been not been adhered to by you. So in that first point you failed.
my lord, may I submit on that, my lord.
Yes.
My lord, may see to it, my lord, that there were earlier 2 bills.
Maybe, Mr. Council, that is all right. There may be 20,000 other bills also prior to that.
Yes.
The issue is, on the 20,001st bill,
Yes, my lord.
you gave a time limit of 15 days
Yes, my lord.
to pay his current bills plus his arrears.
My lord.
And you have disconnected his electricity temporarily
My lord.
prior to that 15 days period being over in terms of 8.5.1.
my lord.
So on that count, prima facie, we find that, it's not correct. Now, let us see whether the general clause printed in the electricity bill is a valid statutory notice. Whether it is a valid statutory notice, let us see. Let us see under what section.
Under 56.1, my lord.
Let us see where it is. Where is
My lord, disconnection of supply in default of payment. My
Give
lord
us-
has the
give us the law.
Electricity Act.
Yes. And but I've also furnished a judgment of the Honorable Supreme Court where the courts have said,
We did one at a time, Mr. Counsel.
let's.
You see, unfortunately, they are not like the Marwari businessmen who can have 5 telephones,
Very well.
one here, and they can have a fluent and sensible conversation with different persons. That capacity we don't have. One is enough. Two also we're having problem. Yes, which section?
My lord, 56.1.
Yes.
Where any person neglects to pay any charge for electricity or any sum other than a charge for electricity due from him to a licensee or a generating company in respect of supply, transmission, or distribution or wheeling of electricity to him, the licensee or generating company may, after giving not less than 15 clear days notice in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off the supply electricity and for that purpose cut or disconnect any electricity supply line or other works being the property of such licensee or the generating company through which electricity may have been supplied.
Yes.
Yes.
This is after giving,
Being not less than.
not less than.
15.
So you have to give 15 days time. After you have given a notice, is as per your own stand, the notice period in your bill is from 13 to 28.
Yes, my lord.
Now, prior to 28, you have cut him off on 20. So that 15 days has not been adhered to by you in terms of this section 56.
My lord, I'm accepting my lord's submission that on 28th we should have cut it, but we have cut it on 20th. But my lord, did he ever raise that issue? Did he ever raise that issue? Because this in notice of
The raising of that issue, we are raising the issue.
because the 15, my lord, we had given him when we intimated him in 2011. My lord may see before that he was not even bothered that what is the status of his house and what is the electricity connection there.
That is there.
So my lord,
That is there.
my lord,
He's clutching at whatever is there for him to look clutch at.
so my lord may just look at my lord at 8.2.1, my lord, that my lord will file the written argument.
Where a person neglects to pay any charge for electricity
Any or some due from him to licensee, but the date by the due date mentioned in the bill in respect of supply, transmission, or distribution or wheeling of electricity, the licensee may, after giving not less than 15 clear days in writing to such person and without prejudice to his rights to recover such charge or other sum by suit, cut off supply electricity until such charge or other sum together with any expense incurred by him in cutting off and recurring are paid but not longer. The licensee shall not be entitled to terminate the power supply in case a person deposit under protest an amount equal to the sum claimed from him or the electricity charge due from him from each month calculated based on the average of past 6 months for the period under dispute, whichever is lower. So, my lord, there was a proviso. Now,
So what does it say? The licensee shall not be permitted.
Shall not be entitled.
Shall not be entitled to terminate.
Yes.
The power
Supply
supply in case the person
Is
deposits
it under protest?
under protest
Yes.
an amount equal to the sum claimed from it. So that has been
My
paid.
lord, and below that, electric charges due from him for each month calculated based on the average of past 6 months. So, my lord, he paid on 2022.
Correct.
Yes, more than the 6 months have gone by. Now, my lord may see.
There was a mistake committed by you with regard to the date. You should not have mentioned the 20. You should have mentioned any date after 28. Anyway,
Now, my lord,
that is okay. It's supposing it's a mistake.
Yes,
Then what is your thing?
but it's not a mistake because
my lord,
Then it was never an issue with you.
Mulaj, what had happened was at that point in time, as I'd already pointed out, Mulaj, if all the past bills are seen from which have been recovered from us, all were deposited in the office of the APDCL Mulaj, physically. Now, this is during COVID period. We could not do it. We did not receive any notice. When we did finally the first annexure, Your Lordship, which had noticed the PDC bill, where the meter status is shown as running and the last date is given as 29. And then the moment we discovered it, we expeditiously moved to the APDCL office. And on the last date on 29th, we paid all the arrears. We paid all the arrears. There's a receipt on record and they do not deny it. So before the last date, we make all clearances and then they assure us that everything will be rectified. And now they come and tell us that the disconnection had taken place long back, for which no notice was served. Also, Milord, the notice which the section 18, the format 18 notice which they refer to, where it is written at day 20, this was supposed, Your Lordship may kindly come to 8.2.
Just
Yes.
1 minute.
And minutes.
Just a minute. Just a minute. You see, when you look at these provisions,
my lord,
now you're saying that the notice is reflected in the bill itself.
my lord.
Come to section 1671 of the Electricity Act. 171.
My lord, I'm aware of this section that affects. My lord, if this is taken in,
This is a statutory law.
I understand, my lord. But my lord, this was a time, my lord, this was a time when if the COVID was also happening for them, the COVID is also happening to the employees also. So there was this method.
So the law should be kept in
No, no,
suspended animation.
No, I'm not saying that, my lord. My lord, he is taking the pretext of service of notice of under section 171. But what we are stating is that, my lord, the bills had the notice itself. And
But can the bills override the provisions of the act?
my lord, this says that every notice or order under act or authorized to be addressed to any person may be served upon him by daily after opening signed acknowledgement receipt thereof.
Signed acknowledgement
Right?
receipt. Show me
Yes.
that.
My lord, now may I just come in here, my lord? The bills which are sent to every APDCL consumers here, my lord. Earlier it was by post, registered post. Then the notification changed and everything happened. Now, then it started coming digitally, my lord, to everyone. That is why the section 56(1), that statutory thing that you have to pay within 15 days, started being imprinted in the notice
6(1) of what?
of the Electricity Act.
56(1). Let us see what does it say.
My lord, just read it, my lord, where it says the 15 days.
I'm reading it.
Yes. Where any person
Yes.
neglects to pay any charge for electricity.
This is with regard to disconnection.
Yes.
I'm not talking about that. I'm on the issue of what constitutes a proper notice in terms of the act. Now, according to you,
My lord.
the bill contains a period of 15 days,
My lord.
and that by itself constitutes notice.
My lord.
Now, whether that is in terms of the act, whether that can be considered to be a notice in terms of section 171.
My lord, in that parlance, I would like to say the other notices, the termination notices and other notices.
On that.
were-
Let
were
us go one by,
communicated.
let us go one by one.
Yes.
Let us go by one. The bill, Electricity Act, the bill is a bill.
Yes.
If we notice, it has to follow 171. An electricity bill, if you say that it is a notice also, it has to follow the provisions of 171. If it complies with the provisions of 171, it's okay. If you say that because of COVID, this law should not be considered, that's a different issue. You can say that, but probably we will say that murder is murder even in times of COVID.
I'm not suggesting that, my lord. My lord, what I'm suggesting is that that the bill which we have placed, that also includes the notice.
Now, another point.
Yes, my lord.
Come to this 8.3b.
Yes, my lord.
Disconnection.
Yes, my lord. Yes, my lord. If the cause of which supply was stemmed is not removed within the notice period.
Is not removed within the notice period.
Yes, my lord.
Now, according to you,
Yes.
where is the notice under 171?
The PDC notice, my lord.
Where is that? Does it have? I'm again coming to the issue.
Yes, my lord.
Of what constitutes a notice as per the Electricity Act.
I absolutely understand what my lord's falling from, but once the notice of temporary disconnection was communicated to him, my lord may see this. My lord may see the observation.
Another thing, come 8.2.3. Yeah, I'm both missing the point.
Yes, my lord.
Not going to all the things. Come to 8.2.3.
Yes, my lord.
If any service,
yes, my lord,
is disconnected on account of non-payment of electricity charges or other charges due to licensee.
Yes, my lord.
The consumer has to pay the charges for disconnection and reconnection.
Yes, my lord.
The licensee shall restore.
Yes, my lord.
The electrical supply within 24 hours.
Yes, my lord.
And 48 hours.
My lord, that is for temporary disconnection. My lord may see.
Temporary disconnection.
Yes.
Now.
Yes.
For that permanent disconnection to take place.
Yes, my lord.
You had given him
45 days.
Till 29th.
My lord.
Yeah?
28 balloon.
20. No. The other one, 346 or something. What is that thing?
The last date, my lord, 29th of March.
29th of March.
29th of March.
So he has paid it on 29th.
No, my lord, my lord, this is absolute, my lord, let me put the facts in the what has been submitted by the petition is absolutely wrong, my lord. My lord, may I just come in here. My lord, what has happened here is that we first gave him a temporary notice. That is on 16/11/2021. My lord, may I just note it, my lord.
No.
My lord,
See that notice,
yes, my lord, that is at format 18, page 85.
page 85.
Yes, my lord.
Let me see. Now, the first, we'll go step by step.
Yes, my lord. My lord.
Now, whether page 85
Yes.
can be said to be a notice.
Yes, my
under
lord. My lord,
section-
with that,
Uh,
my lord has to read 8.2.2, disconnection on other reasons.
No. First of all,
Yes, my lord.
your 8.2.2 is what? What is this? It
My
is
lord,
a,
disconnection on
no, it is, what is this? It is a
temporary disconnection, my lord.
it is a,
Temporary disconnection.
it is a code. Right?
Yes.
It is the electricity supply code.
Yes.
Correct?
Yes, my lord.
Now, this takes its power. This code
Yes, my lord.
has been created on the basis of the power given under the Electricity Act.
Yes, my lord. That is
So supposing there is supposing there is a discrepancy or a contradiction between the code and the act, can the court supersede the act?
not at all, my lord. Not at all.
If that is the case, then whether a notice to be considered to be a notice would have to be decided in terms of the code or the act.
My lord, for that, I would rely on the learned single judge judgment, the finding of it, my lord.
No, I'm not on that.
Yes.
We are on the law.
Yes.
Where
My
on the
lord.
law, can the creature
Yes.
that has been created out of an act supersede the act?
No, my lord, we have not created
Can the rules supersede the act?
No, my lord. We have not created a creature outside the rules. Outside. Let me show it to my lord.
So the simple thing is whether the notice
Yes.
is as per 171 of the act. That's all.
Yes, my lord. I'm coming to that, my lord. My lord's first question is that whether my notice under section, whether the notice of disconnection, so 171 says about notice that has to be supplied to the petitioner when there is some kind of a disconnection has happened.
Whether it is temporary or permanent.
Yes.
Show me.
Yeah.
Just show us
Yes.
the notice. That's all.
Yes.
Just show the
My
notice.
lord, that note.
It has been signed.
Yes. My lord. Now, my lord, for that section, for that, my lord, we have given him a electricity bill. My lord, just hear me for a minute, my lord. I request.
Heard you
Yes.
from no,
Yes.
no point where you're going round and round.
Oh, no, my lord, I'm not going on, my lord.
Like
There is an observation by the learned single judge where he himself has admitted that at para 108, that it is seen that long with the affidavit in reply, the petitioner has produced a copy of letter dated 8/4/2022 by the subdivisional engineer Jew Road Electrical Subdivision, which was in response to the advocate's notice by which the petitioner was informed that electricity supplied to his premises was permanently disconnected on 14/3/2022. However, in the body of the said letter, there is a handwritten note which appears to be made by the petitioner mentioning that this is reply to the legal notice. It is clearly demonstrate that notice, if at all, was given only on 6/11/2021, whereas it was temporarily disconnected on 2030, for which no notice was given. Thus, it appears.
Which
Page 108, my lord.
which para?
Para 12.
Letter issued by the which has in response to the case notice. Produce the copy of the letter. This is a letter. This is not a notice.
Yes, my lord, thus it appears from the document produced by the petitioner that electricity supply was disconnected to his premises on so and so. Hence, as per the document produced by the petitioner, the permanent disconnection was done on 14/3/2022, was far beyond the 180 as prescribed by the regulation so and so. So, in this regard, we may refer to the observation made by so and so. So, my lord, my question is this, my lord, the notice, my lord, which my lord is attaching to 171, that is a temporary disconnection notice, and which he has already given he already got a copy. My lord, the PDC also he has got a copy, my lord.
This page, this section 171,
My lord.
does not speak of a temporary.
Yes.
Sorry, don't you see? Please be fair to
My
the
lord.
court.
By being fair to the court, my lord.
Where does the word temporary come in? Show me. in the section 171,
My lord,
where does
it's,
the word temporary come into
man,
play?
it says every notice.
So every notice means what? Only temporary?
No, my lord, then, my lord, the first bill itself contains our notice.
Okay, we have heard it.
But if I may just point out two, three more illegalities, that the notice which they constantly refer to 85, according to their own regulation, was to be served, is mandated to be served within 24 hours of the temporary disconnection, which was not done in this case. After 11 months, they purportedly served. Purportedly. In our rejoinder affidavit, second point, we have made specific averments that this was never served to us, as rightly pointed out by our lordships also. There is no signature. It was never served to us, to which they did not give any reply. The intention of creating this format 18 notice is to put the consumer on notice that temporary disconnection has taken place. So you rectify it. This was never served to us. And the last also, Mullah, even after permanent disconnection also, format 20 notice has to be served to us, which was also never, till date, never been served to us. So these are the additional illegal.
21 is format.
I'll take your lordship to 8.8, 8.4, Mullah. 8.3, permanent disconnection.
Yes.
Before that, on the same page, the first one at 8.2.2, the last line, the licensee shall intimate the consumer in case of his temporary disconnection in the format 18 of this code within 24 hours of disconnection.
That hasn't been done. That hasn't been done.
That hasn't been done. That has admittedly not been done.
Because of that letter of 2021,
Malas.
which has shown that disconnection at
Yes.
on 20th August.
Yes, ma'am.
No,
And I'll come to permanent disconnection. Next page, 8.3, last line, my lord. After termination of all agreement, the licensee shall intimate the consumer in the format 20 of this code. Till date, never done.
That also hasn't been done.
That also has never been done.
My
Till
lord,
date, my lord.
my lord,
No,
format
what is
20
the answer to that?
yes, my lord, format 20 is for intimation of consumer after termination of agreement. We do not have any kind of an agreement with him. My lord, we see the heading, my lord, intimation.
We're not on that. You see, we're on this. We're on the simple thing
My lord,
that you see the issue boils down to issuance of a notice.
my lord.
The entire issue has arisen from whether notice was given and whether that notice is as per the act. Now there is no notice as per the act, and when something is wrong from the very beginning, from the very inception, what remains?
My lord, the note, I am again coming, my lord, the electricity bill contained a disconnection notice. It's just type it. That's what the 79, 80, 77, 76, all the bills stated that. And it is not only for him, it's for all the consumers of APDCL.
So
What,
then what is the requirement of 171?
my lord,
Section 171.
my lord, 171 says that a notice has to be sent. And that is, if that has to take it in question from now on, my lord, we have to send every bill and we have to get it.
You have to send every bill. Only when they don't bring their bill,
Yes.
you send 171 notice, whereupon you need to take their signature. That's the only difference.
What is the agreement as per you?
My lord, the agreement will be as per the, for that, my lord has to come as 5, execution of an agreement. That will be 5.2, my lord.
5.2.
Yes, my lord.
Where is that 5.2? 5.2 of this code?
Yes, my lord. Of the code, my lord. If my lord, I don't think my lord has a copy of.
Yes, we don't have. Let us see the code. 5.2. So they must have got a new connection. That's what they got.
To interpret the term agreement, Mullah, the definition clause has to be seen, Mullah. The definition clause.
My lord, at 8.2 at a disconnection, my lord may see there are 2 proviso. One is 1 and then is 2.
What is this format 20?
Mullah,
It's
it's in the code, Mullah.
It's in the code.
itself.
And my lord may see here.
At page number 205 of the code, Mullah. Towards the end, appendixes. 205 is the format 18 and 207 is the format 20. 18 is for temporary and 20 is for permanent.
My lord, may see the line.
He's going to have a connection, then.
My lord, may see the line here at format 20. This is the information agreement dated. There was no agreement as such that we have entered with him, my lord.
You see, whenever there's a new connection,
My lord.
there has to be an agreement. Without an agreement, you cannot have a new connection.
Yeah.
My lord,
I cannot get electricity without the agreement.
Get electricity.
my lord may see once, my lord may see, my lord, on the 8.3 permanent disconnection, the supply shall be disconnected permanently on following on the termination of an agreement. If the cause of which supply was temporary is not removed within the notice period.
Correct.
Either of the two.
Ah.
Here it is not because of termination of the agreement, my lord. If there was a termination of the agreement, then we would have gone for format 20. My lord, 8.3, my lord, may just the supply shall be disconnected permanently in following cases on the termination of agreement, and second, if the cause of which the supply was temporarily disconnected is not removed within the notice period. So we have here disconnected his because he did not pay within the notice period. So for that, format 20 is not required, my lord. The proviso is there next line. Provided that if the service comes and remains continuously disconnected.
You reconnect his electricity plant.
My lord, we are ready to give him the fresh connection. My lord, he is not, even the interim order state him. He does. He
Yes,
needs a
Mr.
new-
Council, you get the reconnection that you don't have to pay, you don't have to get a new connection, you can reconnect.
Yes, yes. We are stating for that. They're saying that they cannot get reconnected.
My lord,
They're saying I'll have to
my
take
lord,
new
he is
connection.
saying,
Mr. Council,
Balance.
you have said now,
yes.
reconnection you can give,
Yes.
you want reconnection?
I agree.
What's the matter?
My
I
lord,
agree.
my lord,
You see, you see,
Yes.
the thing is that,
yes, my lord,
very simple,
yes,
case is only, the genesis of the case is the notice.
yes.
The notice is under 171, it is not.
My lord, I'm on record.
But at the end of the day, after all things said and done,
Yes,
he cannot claim any compensation
yes,
on
my
account of any loss of income. For that, he has to go to the district.
Yes.
my lord,
Now, he has now limited his case
yes.
only to the question of reconnection.
Yes.
No, no.
Balance.
And you have also said that we will give him reconnection, not a new connection.
My lord,
Reconnection.
my lord, may I just, the reconnection would be the new meter and everything. He's not agreeing to that.
No, no. How can he? How can he? That is being that we will.
My lord, my lord, we cannot have the, we cannot bring
Right.
old meter.
Why not?
No, we cannot bring the old consumer number, everything, my lord. Now the everything is smart, smart when Peter has come up, my lord.
Huh?
So now it is smart prepaid meters have come up,
Then we will pass the order. We'll
Yes.
do it. We'll go to Supreme Court.
my lord.
Liberty may be granted to agitate as far as the fund. Yes. Obligations.
My lord, the reconnection, we will give reconnection as per the new, because nowadays, my lord, the old meters and the smart meter, nowadays all smart.
You change your code. Once your code says that you cannot give new, you cannot give a reconnection, then
My
then we'll
lord,
understand.
my lord, we are saying,
Code says that you can reconnect at the end of the matter.
my lord,
Yes. Obliged.
Not go beyond the.
no, my lord, I'm not going beyond, my lord. My lord may just hear me once, my lord. What I'm saying is,
That will amount to allowing
lord.
your point to stand.
no, my lord,
Don't find
what
it.
I'm suggesting here is, my lord.
I think you are saying something.
Yes.
In code, the
No, the code clearly says,
You are saying that
Heard, Mr.
changed.
A Sahu.
Huh?
A Sahu.
Yes, sir.
the code does not, my lord, the code does not say that there's a reconnection should be given after temporary disconnection, after permanent disconnection. It clearly stipulates that 8.2 it's finished and 8.3 it starts. My lord, there cannot be a reconnection of something which is already dead. So we can give him a new connection. We will give him a new connection.
The difference between, you see, you can do it. It's the only thing is that a new connection would require paying a new set of.
My lord, we are ready to forego the price. We are ready to forego whatever he has to pay. We cannot give him the connection which was holding back in 2020 because, my lord, that meter is already dead. The status of meter says running, my lord.
You see, a meat is dead.
Yes,
Can't it be revived?
my lord.
Well, you see, when there is a temporary disconnection, does it mean that in a temporary disconnection, the meter would keep on running? Is it your case? No, just answer me simple. Don't tell me
Yes, my lord.
too smart.
Yes, my lord.
Just answer this question. Whether in a temporary disconnection,
My lord.
would the meter be dead or the meter would keep running?
In temperature, the meter would keep running, my lord. And within 45 days, if he pays, we again reconnect that. That is why the reconnection and disconnection charges are there. The moment the 45 days are period, it becomes disconnected. The meter, we dismantle the meter, we bring back, and only the area is charges. That is why he's saying that he was not using electricity. It's not because of that.
So you have taken away the meter.
Yes, and now everywhere, not only his, every household of Assam is having smart meters. So we are saying that we will give you a new connection. We have even communicated him to it.
So you do one thing.
But what we
So you give the new meter,
yes, my lord.
but you all take the charges for a reconnection, not for a.
Yes, my lord. We are ready to do that. That's what I'm suggesting.
Another matter.
Yes.
We have suggested that even in mediating also.
We have already paid the reconnection fees, the receipt of which.
Then why were we hearing you?
My lord,
all these.
My lord, because he was hesitating. He was hesitating it from the morning. Even the last order of the learned division bench stated that, but he is not agreeing to it. He needs the old meter number, old everything. How can we give that?
From the very beginning, I just said, my lord, that I am aggrieved by the finding that the termination is right. If that goes, my lord, I have nothing more. Yes.
Wasted time. It took us a lot of effort to understand your case.
My lord.
But to
My lord, in fact, the learned single judge, yes, we already have given them the liberty. He did not apply. He never applied. And I've been asking that you apply.
yes, also you also the ego problem. Ego problem. But legally he's correct,
Yes.
but practically you're correct.
Even the
Well,
learned
it's-
single
they-
judge
they-
gave
they
him a
have-
liberty that you file. We agreed to it. He did not even file for any application.
Well,
We said
it's-
we'll forego.
That would amount to
That-
getting a new connection. They have all the details from our previous connection. They can give us a new connection.
He's
giving you now,
he's giving you a new connection.
But he's asking me to apply fresh. That is the problem. That is the problem.
My lord, we are not. We never have asked. We have
That
never.
may be recorded. I'm sorry.
Yes, we never. We have asked that you submit the documents that you have submitted earlier. You give those documents because we.
Same
will-
thing.
Submit early meaning.
My lord, there are set of documents which are required.
At the
For
time of fresh connection.
we are just saying you give those documents. We will give you a
If you give
Yeah, you
fake
give
document, what is
new
that?
connection.
Well,
We'll follow the
I
charges.
will have no problem.
What's the problem? You
I will
give a
have
fake
no problem.
document. We'll direct that the charges for reconnection should be paid and not for a new.
Well, charges for reconnection have already been paid.
Yes,
which have not been-
we are ready to adjust it.
Then you will.
Yes, my lord.
But like I said, my lord, my grievance is only confined to the finding of the learned single judge. The determination was valid. That is the only confinement.
My lord, his
And as I
entire
said,
thing
as
that
far as,
if the disconnection
compensation
is
is concerned,
legal, he will file a damages suit and he will try
That
to.
I will, my lord.
That's what his intention.
That
That's
I
why
will.
he has been arguing this.
That I will before the concerned court, my lord, for compensation.
Yes.
How will you? You're not even living there in your house.
My lords, the tenants had to vacate.
That
it
is his
due to the
entire intention,
disconnection.
not this notice and everything. It is just to extract how
How
because we have been
So,
writing, we have been talking to him we have been mediating. We are losing a consumer. You file it, we'll forego everything. Everything was there on record. It was there, but still he never there.
Why? Profession not giving you enough.
my lords, we complied with all statutory requirements. We did the reconnection. We paid the reconnection bill also.
Okay, right. Heard, Mr.
Yes, Sahu. My lords.
Learned counsel for the appellant. Also heard, Mr.
SP Sharma, man.
SP Sharma, learned counsel for the IPC.
He's my older respondent, man.
All the
Except state.
appellant is aggrieved with the order dated, impugned order dated 25/5/2020. Passed by the learned single judge, WPC 2697 of 2020. By which have you filed Vakalatnama?
Yes, my lord. Anjan Sahu, my lord.
It is there, the Vakalatnama is there.
It should be there. It is, my lords.
Huh?
Yes, my lords.
I hope it is there. We have been hearing you. I want to discuss this matter.
My lords.
Otherwise, they have got.
Before the learned single judge, the petitioner was appearing in person, my lords. But before the
That is not the question.
Right, my lords.
The question is before this court, have you filed your wakalatnama?
But because it was heard and reserved by the previous bench also for orders. After
If you have not filed, please file mention memo. I mean, memo of appearance or something like that.
I'll do that. I'll do that.
Still, we still that far, I think.
Reflection of last order would have been cleared, man. The Chief Justice also directed him that you do it. He didn't even do it. On the 28th of August.
Last order, what?
Yes, man.
There was a last order.
Yes, man.
The inspection were, okay.
Yes, my lords. I was to come back with instructions today.
Yes.
And I'm agreeing that I will supply what they're saying, but they're just saying that there
You
is
see-
fresh connection to which we're not agreeing to. And as far as the submission of documents is concerned, we'll comply with that.
What have I said? By which? The issuance of the permanent disconnection bill, bracket PDC. Permanent disconnection, bracket PDC, bill dated 14/3/2022 cannot be said to be illegal. During the process of arguments, the learned counsel for the respondent has submitted that even though the appellant would have to be given a fresh connection, electricity connection. In view of,
One of the one of the code is there. 3.2, I will.
but the respondents would be agreeable to charge the applicant.
4.1.
4.1, huh? 4.1 of the what code?
AERC code.
AERC code. Comma. The respondents would be agreeable if the appellant pays only the reconnection charges,
Which is already paid.
which has already been paid. Full stop. The respondents would not charge any, would not claim any charges for a new electricity connector. Then I won't go into the issues.
Let's kindly.
He however submits that the appellant would have to submit
The documents as mentioned in 4.2.
the required documents as mentioned in
4.1.
4.1 of the AERC code for getting the new electricity connection. The counsel for the appellant submits that he is agreeable to the proposal made by the counsel for the respondent. He however pleads that he may be given the liberty to approach the civil court.
Some finding, Milords. Otherwise, the learned single judge's order will be sustained.
Be against you. We will not.
Otherwise, Milords, even if we approach
Hello,
the
that is the
district
intent I
court
told you.
for compensation, even if we approach, then the learned single judge.
Give any finding in your favor. If you want to give any, if you want me to give any finding, if you want us to give any finding, then we need some material.
Well, it's not on compensation. I'm not saying on
Okay,
compensation. I'm requesting for a finding on the termination itself, Mulad, on the termination, just the termination of the connection, because Mulad, that will have a ripple effect because all the illegalities committed by them will then be solidified, Mulad. Because the learned single judge has clearly held that the termination is legal, is valid. I am challenging that it is not legal.
Setting aside the single judge order.
That may be done.
We'll set it-
Setting aside, yes, no. And it may be,
we will-
termination may be deemed illegal, Mulad. That is all I'm saying. Because
No, no.
if it is set aside, Mulad,
No, no, we're setting aside, we are not making any, we are not, we are saying that we're not deciding this case on merits.
then Mulad,
If you want me to, if you want us to decide on merit, then it'll take time. We will do it.
Mulad, if your lordship, I would pray for that,
But-
Mulad, because this will have a ripple effect, Mulad.
Huh?
This will have a ripple effect, cascading effect, because the notice, all the observations that have been made orally, Mulad, if they will be solidified and they will be manifested otherwise, Mulad. That is all I'm praying for.
We will dispose of on merit, but we will dismiss your claim for,
Of-
for damages. My lord. You can go to Supreme Court for damages. It's a two-edged sword, Mr. Gandhi. You cannot have your cake and eat it too.
I
You see, so either you, because you have decided so that we said this, now you want more. If you want, we will allow your thing that you should get that the notice was bad,
right, Mulad.
but we will dismiss your claim for damage.
Mulad, at this point, Mulad, we would prefer the finding, Mulad. We can forego the compensation also, if your lordship may believe.
So where is your claim for damages? In your
Writ petition, Mulad.
It's not them.
huh?
At page number 42, Mulad. Number 4, award compensation and damages to the petitioner.
From there, there.
It is there, Mulad. Right. 42.
Yes, and what is your how much are you claiming?
Mulad's 5 years, Mulad.
And where is that?
The petition. In the rejoinder affidavit, Mulad. The rejoinder affidavit, we have annexed the
Join the affidavit here. Fine, my lord.
page number 98, Mulad, of the appeal. This was with the Bhutan Airways tenant,
96, my lord, page.
page number 98.
Is this document a registered document under the Registration Act?
Mulad, that it is not.
So this is a
We just annexed it to exhibit how much rent we were getting it.
So we will say that this cannot be applicable.
Right.
This is not a registered document.
Right. Right.
My lord, we have this one line, man, because it will have a cascading effect on us also, because then we have to start issuing notice to everything on on the this bills, because now the smart meters, everyone gets their bills over there. So
No,
that,
you see, there is, you see, there's something, we are slightly disappointed with the appellant's counsel in, changing his mind like
Yeah.
that. So there are ways to,
my lord.
there are, in our thing, there's 100 ways to cut a chicken.
Yes, my lord.
So we take care of that,
Much obliged.
take care of it.
No, please, I apologize.
You will have to go.
Mulad, our only confinement is to the finding, Mulad. That's
We will,
just the finding, Mulad.
but we don't know now, huh? How it will. Right. Heard. Mr. A. Sahu, Madam Counsel for the appellant. Also heard Mr.
SP Sharma.
S.P. Sharma, Madam Counsel for the response. Whatever, the appellant is agreed by the order dated 25/5/2020. Passed in WPC 2697 of 2020. By which the single judge has held that the issuance of the permanent disconnection bracket EDC license bill dated 14/3/2020 cannot be said to be illegal. Not be said. The facts of the case is that the appellant is a senior and he is aggrieved with the electricity supply that had been disconnected from his house, which he had rented out to somebody else. The electricity connection had been disconnected by the respondent with effect from 20/08/2020 due to non-payment of his electricity due from which month did it start?
It started from 1st February 2020.
Did you get that?
As per their counter affidavit, my lord,
1st of May, 1st of May, page 77.
Page 27.
Yes, ma'am. At top right, my lord. Bill period.
First of May, page 77.
Yes, my lord. For 1/5/2020 to 1/6/2020.
No, cannot be first of. Where's first of?
Yes, my lord. First bill period.
But there is already arrear out there.
Yes, my lord. That bill is not attached, but 9 to 8 demands. So that will be. So, my lord, it was we have attached from 1st of May.
So there has been an arrear prior to that also.
Yes, my lord. Maybe it must be in the month of April because it's 928 demand. On the current demand 928.
What have I said? From the year 2020. Let's say from the year. While intimation dated 16/11/20. The appellant's case is that the disconnection was carried out illegally and in violation of the statutory provisions and the electricity supply code framed by the Assam Electricity Regulatory Commission. The further case, the further case of the appellant is that though the action of the respondents was unlawful, he went ahead and paid all the alleged arrears. When I paid all the arrears within time. So despite the same, the respondent did not restore his electricity supply. and instead permanently disconnected his electricity. As the appellant was of the view that the arbitrary conduct of the respondent had resulted in the appellant sustaining loss due to what? Loss due to what?
The lack of electricity, my lord.
Due to lack of electricity.
The vacation of the premises by the tenant due to lack of
And
electricity.
due to vacation of his premises by the tenant due to loss of electricity. And the respondents wanted the petitioner, the appellant to apply for a new electricity connection. The petitioner filed a writ petition before the learned Commission. The said writ petition having been dismissed, the present appeal has been filed. Next. The appellant's counsel submit that the temporary and connection of this electricity on the premises of the appellant Victor East Tower had been done in gross violation of the law. He submits that regulation 8.2.1 of the
AERC.
AERC code 2000
17
2017 provides that power supply can be temporarily disconnected after serving a written notice of at least 15 days. But however, in this case, neither was the 15 days period provided by the respondent. Prior disconnecting the petition, the appellants electricity supply.
My lord, temporarily disconnecting. That first will be
Temporarily disconnected.
then it will be permanent.
Both, but don't say them. As the disconnection had been done. Without following regulation 8.2.1, correct?
Yes.
The learned single, what have I said? No, though the disconnection had been done, what? Just read what have I said? Last time. No, though the disconnection had been done without following regulation 8.2.1. Yet the learned single that failed to examine this. Yet the learned secret that health, what is it hold?
That was page number 112 of the writ appeal. That will be internal page number 11 of the impugn order. At paragraph number 21.
That the disconnection of the petitioner's electricity was not illegal. And that the petitioner and that the appellant would have to pay all the reconnection, no, or have to pay all the charges for a new connection of electricity. The learned counsel for the appellants for this. The portion printed in the electricity bill that supply may be discontinued for payment, for non-payment of arrears after the due date of payment expired, was sufficient notice. Correct? That's all. I think we will rise because he's but single way. I would like to dictate in front of you all because that fact. Anyway, because there's a fix of time now because of it. Really, but we'll pass an order. But this is matter again on because I just got the issue of the.
Madam.
This is matter again on. One thing, let us see your agreement. Your agreement.
Expiring 2016.
That's what.
That was for exhibiting how much the rent was, my lord, at that point in time.
Not a registered document.
But for a period less than 11, 12 months, but need not be registered. That's
Close enough. For a period of less than 11 months.
Registration is not, as per section 11,
Yeah.
less than 11 months, registration is not required. That's what he's submitting. And that's, but he's only 2016 and our effect came from 2020.
2020. So there's nothing to show that there was any tenant.
Yes.
very well, but it's as far as the compensation is concerned. I would have no quarrel with that, my lord. No qualms with that.
Might have some quarrel after we pass the order.
Much obliged, Mala.
Lots of.
My lord, item number 10, my lord. The series, my lord. The series.
Time they,
We are very eager for morning.
then they agreed and he's not agreeing. This is
Can it be taken up
the way they have behaved.
tomorrow, my lord? Can it be taken up tomorrow, my lord?
Tomorrow we have fixed.
Your lordship, I have heard.
Fixed a lot of items, Mr. Council.
Let it be treated as part of the.
No.
Soon, my lord.
We have got too many.
Your lordship has heard of it.
I have heard a number of matters. This also I have heard.
So date will be fixed, my
Probably, my
lord.
lord will have the writ petitions, writ appeals and other things tomorrow, fine. Because your lordship is having the
That is what, that is the problem I have.
1 and 2.
Give me one fixed time. This matter, if they had agreed, I heard, then they agreed, then they did not agree.
But can it be on Thursday, my lord? Possible, not possible.
After 22 lordship, because next week there are lots of matters.
Fixed, too many matters. Yeah.
Then it will go after vacation. That's what I.
Vacation अभी certain दियो.
होगा?
After vacation दियो करो. 30th October? Is it
The matter.
3-0.
May I please, Lordship? Lordship, item number 13, Lordship, this appellant is going to retire this month. Lordship, may I play, Lordship, matter be listed on next Tuesday, Lordship? There may be another division bench also, Lordship. Lordship.
Is the matter on Tuesday?
16th.
My brother got a single bench.
Obliged.
What about you?
Item number 15.
No time. We have to. Get the matter when after meeting.